Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about family status discrimination. Cases that should have gone to the Supreme Court of Canada, but didn't. A registered nurse in Alberta was struggling with finding childcare arrangements. She asked her employer for an accommodation when they tried to change her shifts to shifts that wouldn't work with her childcare schedule. Her employer would not accommodate. She asked to be moved to casual or part-time status, and her employer refused to do so. Her union stepped in and tried to argue that she was being discriminated against on the basis of her family status, essentially saying that the employer owed her a duty to try and accommodate her childcare needs in the circumstances of the case. As a result, the question arose as to whether she had an obligation to look for alternative arrangements at the initial stages before she could argue that her rights had been violated by the actions of her employer. And the Supreme Court of Canada was ultimately asked to consider two questions. The first question was whether or not it was inconsistent and incompatible with human rights laws that a person should have to accommodate their own difficulties arising as a result of the family status issues, as opposed to the employer having a positive burden to accommodate the individual. The second question that arose before the Supreme Court of Canada in the leave application was whether or not the standard of correctness should apply, in that was family status discrimination in the employment context a question of sufficient national importance that it raised concerns that the decision was rendered incorrectly as opposed to unreasonably. And the Supreme Court of Canada unfortunately declined to hear the case. This case, of course, raises important issues, because putting the burden on somebody who is the subject of some type of a discrimination to seek out their own accommodations without involving their employer before asking their employer to accommodate their human rights or charter rights issues is obviously a significant concern. People who are affected by discrimination on the basis of their family status or on any other immutable characteristic are obviously not supposed to be put in a burden of having to accommodate themselves before asking their employer to accommodate them. And this case sets a potentially dangerous precedent when it comes to the interpretation of human rights legislation, particularly because in the collective agreement and in other agreements that were made with respect to the nurses, the burden was put on the individual. Does this mean that collective agreements, that other types of agreements, that even statutes could oust the regular process that's typically followed in human rights litigation? And does this mean then that in all cases of discrimination, we could eventually see the law functioning to require the person who is subject to the discrimination to ameliorate their own discrimination before asking for some type of an accommodation to deal with it? That seems to be, in essence, discrimination itself. And I think the Supreme Court of Canada missed an opportunity to correct what is, on its face, an apparent wrong in this case, an apparent inapplicable burden that shouldn't have been put on this person who just wanted the opportunity to look after her children and maintain her employment. And unfortunately, the cost came at a time where we're dealing with a shortage of nursing staff, where we're dealing with a pandemic, and where we're dealing with a significant strain on our healthcare services. Wouldn't having more nurses be able to work in more reasonable ways be better at this point in time than actually limiting the ability of nurses to do their jobs simply because they also happen to have children? This was an unfortunate case, and I hope that the Supreme Court of Canada does take the opportunity in the future to re-look at how human rights legislation might be being watered down by agreements made outside the scope of human rights cases. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.